So I should say that we've taken 30 years to get to the point where we're starting to solve some of these issues in biomedicine, but we've only got 4 years on this discovery grant. So we need to solve these problems in the context of bioprinting within the next 4 years. And the other thing I should say is that the little examples that Di had on the previous slide of patents that have been granted in Australia are a selection of patents, but there aren't that many. So we're really at the point where, or at a really preliminary stage. So there have been some patents granted, there are some applications pending under examination at the moment, but it's a real opportunity to preempt the issues that are likely to arise in the context of bioprinting, given what we know has happened in other areas of technology. And so what I thought I would do is to just run through in a little bit more detail the requirements for granting a patent. So what do you need to do to get a patent in bioprinting, and what does that give you? And so I've just listed the requirements for grant of a patent there in no particular detail, but the first thing to note is that there is a threshold test. So in order to be granted a patent, for it to satisfy the examiners, the invention must be patentable. So it must constitute subject matter that's patentable. And this is a generic requirement. So these requirements are contained in patent legislation over the world. So they're fairly consistent. Once that threshold has been met, an invention must be ascertained to be novel when assessed against the prior art. Very important requirement, obviously. Must involve an inventive step, must be useful, and there must be a full description of the claimed patent within the patent application itself. And so I guess the question that we are interested in today is to what extent are bioprinting products and methods patentable, particularly methods associated with bioprinting products and devices. Given that we think what we're likely to see is a real focus on methods, given the customised nature of bioprinting. And I suppose the bespoke nature of many bioprinted products means that methods of producing them are going to become all important. So they're the requirements generically for obtaining a patent. If you want to obtain a patent in Australia, you file a patent application, which is then examined by specialist patent examiners to determine whether or not those patent requirements are met. And that will basically involve detailed consideration of the claims to the invention that are made in the application against the written description and state of the art. So the application or the patent will either be granted or the application will be refused. And once somebody has a patent, it gives them fairly broad rights. So as Di mentioned, it will give basically 20 years of exclusivity. So 20 years in which to exploit the invention, or importantly, to authorise others to exploit the invention. And exploit is defined very broadly. So if you have a product, you can exploit it by making it, hiring it, selling, or otherwise disposing of it, offering to do any of those things, using the product, or importing it. If you have a patent over a method, you are in a position to exploit it by producing a product or exploiting a product resulting from use of that method. So really, really very broad rights. And so it will constitute infringement to do any of those things without the authorisation of the patent holder. So you can see that the patents are a very powerful tool once you have them. Having said that, a patent can be challenged at any time during its 20-year lifespan. And in fact, the BRCA patents, the myriad's BRCA patents, were challenged, I suppose not too far into the life of the patents, but by the time the High Court's decision was handed down, the BRCA patents were a few months off expiry anyway. So it just goes to show you're never out of the woods as a patent holder. You may think you're safe once you've got your patent, but you're not. And patent examiners are, it's an imperfect science. They're fairly overworked. They have a lot of patents to examine, so that they're examined quite quickly. There's no doubt there are invalid patents in the system. So as I said, the initial threshold that needs to be met is that the invention needs to constitute patentable subject matter, which in Australia requires that it be what's known as a manner of manufacture. And there's been case law in relation to this, which I don't want to go into in any detail, but basically the law is that an invention will constitute patentable subject matter where it constitutes an artificially created state of affairs. Okay, so this is this man-made or human-made requirement that has some economic utility. Okay, and that's a test that was laid down by the Australian High Court back in 1959. And so that is the test that Australian courts and Australian patent examiners have been using to determine patentability in areas of new technology since 1959. In relation to methods, given that we think methods are becoming increasingly important, and I should say that's not just in relation to bioprinting, it's in areas of high technology generally. So in diagnostics, in gene editing, in many, many areas, methods are really becoming the research tools of the future. And so it's fair to say generally that for methods to be patentable, to satisfy this manner of manufacture test, they must do more than replicate naturally occurring processes. And when we talk about economic utility, whether there is economic utility, that might mean commercial utility, but also social utility or some utility in the healthcare context. So we talk about economic utility, but potentially, it's a broader concept than just commercial utility. So the requirements, I guess, in other jurisdictions differ to those, given that these are the Australian requirements, but the essence of them is very similar across jurisdictions. And I guess the other thing we would say is that until recently, that threshold for patentability has been quite low. That was until the myriad case came along. And so this case has really thrown into question how that threshold test, the patentable subject matter test, is to be applied when we're looking at new areas of technology. And so in Australia, the case was heard by the High Court, as Di has mentioned, and the decision in Darcy and Myriad Genetics was handed down in 2015. Is it 2 years ago now? And as Di said, it concerned whether or not the BRCA nucleotide sequences were patentable or not. It took years. It took years to get a determination on this, but finally we got it. And Di's intimated already that the High Court held that nucleotide sequences are not patentable in Australia because the claims were to information only. Okay, information from the natural world. There was nothing that meant that they constituted patentable subject matter. So there was no artificially created state of affairs. The High Court confirmed that the test from NRDC, the 1959 case that I talked about on the previous slide, was the test that we should still be using. So they affirmed that they are the questions we should be asking when we are looking at technologies that fall within the established boundaries of patentable subject matter. But the High Court said that when we're looking at areas of new technology, so claims that fall outside the established boundaries of patentable subject matter, and potentially create new categories of patentable subject matter, we need to consider a range of other factors, or we might need to. And the High Court listed a number of factors that they considered to be particularly relevant, not just on the facts of the Darcy and Myriad case, but more generally. And I have paraphrased them, to simplify them. But very generally, they ask questions like, if we granted a patent in this case, would it have a chilling effect on innovation? Would granting a patent impact on some other law? Would a patent be likely to be granted in other jurisdictions? And is it the place of us, the courts, to determine whether or not this subject matter is patentable, or should it be left up to Parliament to make that determination? So invariably, these factors will become relevant in new areas of technology like bioprinting, because they are going to test the bounds of what constitutes patentable subject matter. So, has that cleared things up? Are we now able to say with any certainty what's likely to be patentable and what isn't? Not really. So there are no clear signposts as to how those factors are likely to be applied in Australia. So we have the factors, but we don't really know how they're going to apply, particularly in relation to methods, because the Darcy and Myriad case didn't consider methods. Okay, it didn't consider diagnostic testing methods, so we've got very little guidance as to how they're likely to apply. And since the Darcy decision back in 2015, there have been a few opportunities where the courts might have used those factors laid down in Darcy, but they've somehow found a way around them. They've been really unwilling to engage with them, either by saying that the subject matter they're looking at falls within the established bounds of patentable subject matter, or by just ignoring them completely, which has led to a suggestion that they don't really know how they apply. There's been a real unwillingness of the courts to engage with those factors, which leaves the Australian Patents Office a little bit in the dark as to how to treat methods and how to apply the Darcy factors. Okay, so it's difficult because we don't know how these bioprinting patents are being examined. In the US, and I don't want to go into this in any great detail, Di's alluded to it already, but diagnostic methods in relation to the BRCA gene were at issue in the US Myriad decision. So they have a little bit more guidance as to when diagnostic testing methods will be patentable, which probably doesn't help us a whole lot when we're talking about methods more generally. But we do know that really restrictive rules have been applied to methods of using excluded subject matter in the United States, and there have been a series of cases where these restrictive rules have developed. And so I guess what we would say is that in relation to methods generally, as to whether or not they constitute patentable subject matter, there's a lot of uncertainty around whether or not they are patentable. The other thing I just wanted to mention was software and business method patents, because I think that the law around these is also potentially relevant, given that it's possible that business method patents might constitute enabling technologies for bioprinting. And there have been some pretty restrictive rules. Well, there's been a lot of debate about whether or not they should be patentable or not, and some pretty restrictive rules imposed. So in the US, the decision in Alice and CLS Bank handed down a decision that basically had the effect of invalidating all pure business method patents, which probably wasn't all that surprising. But basically what the court said was that business method patents won't be patentable where the invention claims the performance of well understood routine conventional activities previously known to the industry. So we're in the position in the US where business method patents are probably not patentable, and the status of software patents is uncertain. In Australia, we're a little more liberal with business method patents. So recent case of research affiliates and the Commissioner of Patents, court held that mere computer implementation of a method is not patentable where there's no physical effect beyond that of an abstract method. And that case dealt with computer implemented financial methods. So I guess they're peripheral to bioprinting, but I would say not irrelevant, potentially relevant. And so I suppose in Australia what we would say is that it's possible that business methods are patentable. They've survived a recent Productivity Commission recommendation to abolish them completely. So it's probably the case that they remain patentable in Australia, although on fairly limited grounds. What I want to get onto now is just looking at the ways that Di referred to of preventing patent overreach. So obviously in bioprinting we want patents to be granted, okay? Patents are important to reward innovation, they're an important tool. At the same time, there need to be limits on the ways, I suppose on patents that are granted, but also the ways in which they're used. And so that's what I'm going to talk about now. And Di talked about exclusions from patenting, which is one of the ways that we can limit what constitutes patentable subject matter. And the first ground that I just want to talk about is this ground of morality and public policy. So when should something be declared unpatentable on these grounds? And the International Intellectual Property Agreement, the TRIPS agreement, which harmonises intellectual property laws to some extent around the world, it's possible under TRIPS to exclude subject matter from being patentable on the basis of morality or public policy, either to protect human, animal or plant life or health, or to protect the environment. Okay, so that exclusion is allowed where commercial use would be contrary to morality and public policy. And the European Biotech Directive is a good example. So that contains specific exclusions in line with that morality and public policy exclusion. It prohibits processes for cloning human beings from being patentable, processes for modifying the germline genetic identity of human beings, the use of human embryos for industrial or commercial purposes, and processes for modifying the genetic identity of animals, which are likely to cause them suffering without any substantial medical benefit. Importantly, it doesn't go on to define what constitutes a human embryo. So whenever there is a provision like this in patent legislation, invariably there will be grey areas, and that is one of them. And exactly what constitutes a human embryo was considered in the case of Brussels and Greenpeace, which considered the patentability of stem cells. Okay, so a European case. And important, I suppose, from our perspective, because stem cells are an important tool in becoming an important tool in bioprinting, a potentially important tool when we're looking at creating tissue and potentially organs. And without going into huge amounts of detail, the court said that stem cells that retain the capacity to develop into humans are not patentable. Procedures using stem cells obtained by destroying embryos are not patentable. So if an embryo if stem cells can be removed without destroying the embryo, the court left it open for stem cells to be patentable in that instance. Okay, but that's something that hasn't been tested. Interestingly, in this case, Brussels was using pluripotent stem cells, but used a method which destroyed the embryo in the process. So that question wasn't required to be determined. What if a method's being used which retains the embryo? But potentially, there's some scope for patenting stem cells in that instance. So the court did say in that case that stem cells will be patentable where the developed product is intended for therapeutic or diagnostic purposes which are applied to that embryo itself and are useful to it. Okay, so not really all that surprising. So we have these exceptions around morality and public policy, but there is no specific exemption under Australian law. Okay, so Australia hasn't incorporated an exemption to preclude patentability on the grounds of morality and public policy, although it does contain an exemption where the grant of a patent would be generally inconvenient. Problem is, we don't really know what generally inconvenient means. It's been successfully argued where public access to a freely available product would be adversely affected. So for example, you can't patent a set of instructions for a computer because people who bought that computer won't be able to use it if the instructions are patented. It's only been argued in a few cases, and it is very unclear what it means. So we don't really know whether it incorporates morality considerations or not. Okay, potentially it might. It has been suggested in a case that I'm going to talk about in the next slide that it may be used to exclude methods of medical treatment, although we can't really say definitively whether that's the case. I suppose the point is, though, that potentially it could be used to exempt or to exclude subject matter on the basis that it offends public policy. So, as Di pointed out at the beginning, methods of medical treatment are another area, I suppose, of patentable subject matter that are permitted to be excluded under the TRIPS agreement. They are excluded from patentability in Europe. So surgery, therapy and diagnostic methods are excluded from patentability under the European Patent Convention. There are no exclusions in the US. Okay, so the US patent legislation doesn't exclude methods of medical treatment, nor does the Australian Patents Act. So the situation in Australia relating to methods of medical treatment on the human or animal body are uncertain. There are a couple of cases that give us a little bit of guidance. Apotex and Sanofi Aventis is probably the main one. It's a recent case, relatively recent case, where a method of using a known drug for a new purpose was held to be patentable. Okay, so we do know that to some extent methods of medical treatment may well be patentable in Australia. But at the same time, it seems that methods of surgery, so methods of performing treatment directly on a patient, probably aren't patentable. Okay, there's no specific case law to tell us whether or not this is the case, but it seems questionable, I suppose, whether or not they would be patentable. And there was a comment in the Apotex case that suggested that methods of, or that surgical methods and other in vivo treatment of patients shouldn't be patentable. Okay, but again, nothing specific that we've got to go on. Similarly, methods of implantation and therapy might potentially be excluded as well. But if they were excluded, it would need to be by judges, by the courts, because Parliament hasn't bothered or hasn't taken the step of putting an exclusion in our patents legislation. Importantly, lab-based diagnostics won't be excluded. So even if there were an exclusion in the Patents Act, that wouldn't include ex vivo methods. Okay, so I suppose there are clear considerations there for bioprinting methods. So at what point does something become an in vivo treatment? So if we're using bioprinted products on patients, is that something that would potentially be patentable, or would it fall outside the scope of patentability potentially because it constitutes an in vivo treatment? We thought we should also just talk about experimental use in a little bit more detail. Given that in Australia we now have an exemption for acts done for experimental purposes relating to the subject matter of an invention. So this is really a way of ensuring that research can progress. So if somebody has a patent over a product or a method, it ensures that research can continue, that research can be done on that invention regardless of the existence of the patent. But it needs to be non-commercial research. Okay, so the exemption only applies to non-commercial research. And in the US, the exemption's even narrower. So even research in a university setting probably doesn't fall within their research exemption, because research constitutes the business of a university. So probably fair to say that the Australian exemption is broader than the exemption in the US, although it really just allows research on an invention, not with an invention. Another thing that we have been mulling over is whether or not a therapeutic exemption to infringement might be something worth considering. So this is something that was considered by the Australian Law Reform Commission back in 1994, based on the fact that the US, I think around that, in 2004, I'm a decade out, around that time the US introduced an exception into their patents legislation from infringement for a medical practitioner or a related healthcare entity performing a medical activity. And basically what this does is to say that your surgeons should still be entitled to perform surgery on patients despite the fact that they might be infringing a patent. Okay, and this is, I suppose, a response in the US to the fact that, methods of medical treatment are patentable. So it's limited. It's a limited exception. So it really only it only applies to medical practitioners, and it won't apply if the procedure involves the use of a patented machine or product, or infringes a biotech patent, drug or reagent. So it really is a limited exception. And I think that there is a real scope to ask whether or not that would even apply if we're looking at a bioprinting product. So for example, inserting a device that's been bioprinted into a patient, because there is potentially infringement if there is a patent over the machine that printed the device. So we have no equivalent protection in Australia. Is this something that should be considered? Is it necessary in the bioprinting space? And finally, Di alluded to compulsory licensing and Crown use. And so I won't say a whole lot more about that, except that although an applicant can apply for a compulsory licence, or the government can assert Crown use to use a patent without the authorisation of a patent holder, these provisions have really been used really infrequently. Okay, they're pretty convoluted, they're difficult to understand, but they are there, and it's arguable that the threat of having them there is enough to ensure that patent holders freely disseminate their technology in order to avoid somebody applying for a compulsory licence or the Crown deciding to issue a licence. And in fact, there was talk in relation to the BRCA patents about the government possibly issuing a licence for government use. In the end, that wasn't necessary because the patent holder decided not to enforce those patents. But interestingly, that possibility was there. And just to finish off, I suppose, I think this is a watershed moment. We're at a real turning point here, because we're at the point where there are a number of patent applications pending. We're having patents being granted. And so it is time to ask, what should be the bounds of patentable subject matter in the bioprinting area? To what extent does the law that we have got already feed into whether or not they should constitute patentable subject matter? And which of these tools should be utilised in order to avoid overreach? Because we don't want the situation we've had in other technology areas where patents have been granted fairly prolifically and have set up this, I suppose, generated this sort of toll booth effect. So there's a real opportunity, I think, to consider these issues before they become acute. We've got this difficulty that there are interjurisdictional divergences in the application of patent law and the way that patent overreach is dealt with, but these are all issues, I think, that we need to work through, and the sooner we do it, the better. Thank you.
Thank you very much for covering so much ground, looking at both some of the context in terms of intellectual property in the life sciences and some of the interrelationships in the regulatory soup and exploring patent law and bioprinting. Just listening to both of your talks, I thought there was an undercurrent of quite a strong competition, law and policy theme coming out, both with your comments about the anti-commons and some of the discussions in relation to mechanisms that can be used under patent law to address concerns about access. And there's been a lot of debate in terms of the shake-up of the 3D printing industry and the more niche industry of bioprinting. I wonder what thoughts you have about that relationship between intellectual property and competition policy in this emerging space. Particularly looking at you, Jane, as one of the leading IP and competition lawyers
so I've
in the
done
country.
quite a bit of work in this area, and I have to say it's not a strategy I would consider to be very promising. So, I mean, we've written about this quite a lot. So, competition law is there. There are obviously the misuse of market power provisions, and indeed, if you want to apply for a compulsory licence, you probably need to establish anti-competitive conduct on the part of a patent holder, but that is a difficult thing to do. So it's a difficult thing to do even if you're not dealing with a patent, with intellectual property, but establishing that a patent holder has market power on the basis of its intellectual property is next to impossible. And so I think you're absolutely right. There is an undercurrent of could competition law assist, but I think the reality is that it's probably not a great tool.
Yeah, so that's the problem, isn't it? Competition law is a very blunt instrument, so it's probably an instrument of last resort in many ways. And then competition policy might dictate that we should tinker with the intellectual property system as a way of dealing with the problems rather than getting to the point of engaging with competition law per se. So I think we can use that to influence how our intellectual property laws should look and how our policy with regard to funding research and so on. So to me, government funding of research should be done in a way that promotes innovation but doesn't facilitate anti-competitive conduct at the same time.
Questions? Queries? So?
Are there any restrictions in Australia, like when an organ has been 3D printed? So will that be allowable? Like,
Will it?
If a specific organ has been bioprinted, so it can be patentable as a device, which, if, for example, if it is a heart, it can be patentable as a device which pumps blood.
Yeah, so I would think that there are all sorts of potential patents that might actually get involved in that process. So there'll be various method patents that could be applied to the process of printing the heart. I think you could make an argument that you could patent that in the sense that it's, as you say, an artificial product that creates a means of pumping blood around the human body, for example. So there's...
It doesn't throw up the same issues as, say, gene patents because it's engineered. So I suppose that's sort of a fundamental difference. But I think what you're about to say, Di, is that there might be other impediments, I think. So I think there might be a few things thrown at you to try and prevent
So just wondering, like, what are your thoughts whether such kind of inventions can be restricted or not.
Yeah, and that's a really tricky question, and I guess that goes to the heart of what we were trying to get at. Yes, this is an incredibly important innovation, and the idea that you can actually 3D bioprint a whole heart would be just such an amazing innovation, which has the potential to really transform human health. So yes, we would want to encourage it, and we would want to support innovation in that area. But on the other hand, to actually give one individual a monopoly over the creation of human hearts would be wrong. So finding the right balance is what this is all about. Yes.
So it's possible this might be something that does open up interpretation of the generally inconvenient provision.
Yeah.
So I can imagine that this is an area where morality becomes a key concern. And the other thing is that it might, how it would depend how this bioprinted heart was generated. What are the cellular building blocks that are used? So if it's stem cells, for example, then that opens up a whole host of issues as well. And there's been nothing, no case law in Australia, but I can imagine there would be.
If I was an investor, I'd be quite anxious after hearing your talk and your exploration of all the different problematic areas in terms of patent law, in terms of methods of treatment and genetics and IT and stem cell research.
Yeah.
There's lots of various risks you're really kind of pointing out in terms of possible future scenarios.
Exactly. So we don't have answers, we just have lots and lots of questions, and I think that's the way the future holds. There are lots of questions that we need to consider in this area, and hopefully provide some answers.
I bet if you asked a patent examiner, they wouldn't have the answer either.
No.
Questions, queries? I had kind of sorry, do we have another one? Sorry, there.
Diane, one of your lines in your slides was consent for future use. So coming from the clinician perspective, I'm in the Faculty of Health, radiation therapist, using our patients' CT data sets, MRI data sets, and creating products that we can use from that. Where's the fine line of consent?
Yeah, so this is a really, really tricky question, and obviously there's patient consent in the clinical context and consent for you to undertake research as well. And one of the debates that's going on is whether it's possible to give broad consent rather than specific consent. So, for example, you would know that in the research context generally, you're asked by ethics committees to provide a means for the research participant to give consent to that particular research project. Of course, it comes up in biobanking because this is material that's going to be stored for the long term for future unknown projects, and so the argument is that it should be possible to ask the participant to give broad consent to the whole array of projects that are likely to come up in the long term. But there's a lot of debate in the bioethics literature about whether that's appropriate, whether broad consent is really ethically permissible or not. I think in Australia we're moving more towards acceptance of broad consent, but it's one of those contentious issues that there's no easy question for.
The future event sort of is unknown.
Yeah, exactly.
Do you need to revisit the patient's consent
Yeah.
each and every time?
Yes, and there've been a number of population-wide surveys that have asked this question of patients and participants, and they've often said, no, we don't want to be asked for reconsent every single time. We've given our consent and that's it. Just go ahead and do what you want with our tissue, because we've done it for the purpose of advancing healthcare, and we see this as really important. But so this is where you've almost got a clash between social values and ethical norms.
Yeah.
And it's not clear how those are going to be resolved yet. And of course then you've got the added complication as to what happens when there's unknown findings that need to be reported back to the participant. If they have said that they don't actually want to be formed, informed, is there still an ethical obligation to inform them? So these are the sorts of things that are throwing up just huge issues. And again, we have lots of questions but no clear answers.
Yeah, it's an excellent question. I mean, there's been lots of litigation. You know, Greenbird versus the Miami Children's Hospital was about patenting, you know, research by a population group. Moore versus the University of California had those sorts of questions, and very contentious issues. So really, really excellent kind of question, and kind of throws up some of the inherent questions about what is the relationship between patent law and ethics, and how do you accommodate some of those issues and concerns. Questions, queries? So,
just to add to Mark's comment about the relationship between competition law and patent or IP law in general. I mean, do you see that some of the methods and technologies are becoming more de facto standards or becoming essential for producing something? Because at least I'm from Norway, so I'm familiar with the EU law of discussion of essential facilities and standard parts. So are there other discussions of that in terms of competition?
Yeah. So again, there've been lots of discussions around this, whether there are de facto standards in biomedicine in particular, where you could apply those sorts of FRAND licensing requirements and so on, or looking at standard essential treatments and so on. What the arguments that have been put so far is that each particular diagnostic test or biological technique or so on is so specific, so personalised, that standards are not yet emerging in this area. And so there've been people like Larry Horn and others that have looked at this and looked at the question as to whether we can translate those standards arguments into biomedicine. So I don't think we're at that point yet, but again, questions are being asked. And I think it's a really good thing to consider. It might be the case in bioprinting that you might have more emergence of standards.
So I'm writing something on this at the moment in relation to the Ariosa and Sequenom litigation with Esther Van Zimmeren. I don't know whether you know Esther, and Naomi Hawkins from the UK. And so we're looking at this question as to whether or not non-invasive prenatal testing, the method constitutes a standard. So I think what we'll probably end up saying is that it's very difficult to establish that any diagnostic method or method related, you know, in the health law context constitutes an essential standard. Given that I'm writing the Australian portion of that paper, I think it's going to be next to impossible, because the essential facilities doctrine in Australia is really restrictively applied. So I think it's a long shot. So I think it's, you know, it's certainly arguable that they do invoke standards, but I think that, you know, it's probably just going to be one argument you throw in amongst a host of others.
Rosa Balladini's new book on 3D printing, with her colleagues in Finland, have a nice little chapter on standards and the interrelationship with intellectual property. I think the attraction of standards in relation to bioprinting is trying to resolve some issues in relation to quality and safety. So I think the drive from standards will come from that.
I think
but
it will,
you know,
too.
Historically there has often been lots of problems in terms of intellectual property coping with standards, because there have been enterprising intellectual property owners who've tried to apply intellectual property rights in relation to standards against other players, and exploit that monopoly position. So it remains a very vexed issue. We probably have time for one last question. Yeah, John?
Given the focus on patenting methodologies in the bioprinting process, I was just wondering whether or not you foresee patents going more towards the software and mechanical side of the 3D printing process, or towards the preparation of materials on the biological side across the whole 3D printing process?
I would have to say, well,
I would say both.
I'd say
quite
both.
simply. Yeah.
And I think there's probably less issue with the software side. But I think that we will see increasing numbers of patents over the biological processes, depending on how they're implemented. So I think that they will raise issues, but I think that, I guess when we talk about the increasing number of method patents, that's probably more what we're referring to. Would you agree with that?
Yeah.
And I think that that's where a large number of the issues are going to lie. So depending on how, on the raw materials used, the processes for generating, tissues and organs, I think are going to become all important. And that's where the big bucks are going to lie too. So I think that's where we'll see the patent applications. And actually part of the new study that we're doing will involve a sort of patent landscaping exercise. So, we've had a preliminary look at what's happening in Australia, but we really need to do that on a more global basis and just start tracking, the patents, the granted patents, but also the applications that are starting to be filed.
I'd like to thank very much Nicole and Nielsen for their comprehensive talk.